Welcome guys, today we are reading the Special Marriage Act 1954. If you have already read the Hindu Marriage Act 1955, you will be benefited from this video because in this video we are going to talk about the sections which are different from the Hindu Marriage Act, the most important sections of the Special Marriage Act. Here we shall read in chapter 1 the marriage officers, in chapter 2 the solemnization of special marriages. Here we shall read the condition, notice, objection of marriage, power of marriage officers, procedure, etc. And thereafter in chapter 3 we shall read the registration of marriages celebrated in other forms. In chapter 4 we shall read the consequences of marriage under this act. And again there are chapters, chapter 5, 6, 7, 8. They are similar to the Hindu Marriage Act, and some points we shall discuss from the miscellaneous one also. Now let's dive in the chapter 1. The Special Marriage Act 1954, it is the Act number 43 of 1954, which was enacted in 9th October 1954. Now the definitions, they are just the same of the Hindu Marriage Act: degrees of prohibited relationship, full blood, half blood, uterine blood, district and district court. They are just similar. So we are skipping them. And in section 3, this is important: marriage officers. For the purpose of this act, the state government may, by notification in the official gazette, appoint one or more marriage officers for the whole or any part of the state. For the whole of any part of the state, who has the power to appoint marriage officers? The state government has the power, and by notification in the official gazette, they will appoint the marriage officers. That can be one or more marriage officers. Now we're moving to section 4, which is the conditions of the solemnization of special marriages. These are very important. They are in chapter 2. So first condition, there should not be bigamy, neither party has a spouse living. The second condition, neither party is incapable of giving a valid consent in the consequences of unsoundness of mind. So unsoundness of mind should not be there, and thereafter the suffering, they should not be suffering from a mental disorder which are of such a kind that they become unfit for marriage or the procreation of children. And the third point is, they should not be subjected to recurrent attacks of insanity. So these 3 points are amalgamated in the point B, second condition. Third condition is the age of the parties. The male should be 21 years and the female should be of 18 years, completed the age of 18 years. Now the parties should not be in a degree of prohibited relationship. You have to know there is no subinda condition as per the Hindu Marriage Act. We just have the no degree of prohibited relationship. And for your knowledge, in schedule 1 there is given the prohibited relationship list, uh, which if parties are falling under those person mentioned in the schedule 1, they cannot do the marriage under the section 4 of the Special Marriage Act. These are the main conditions. Now we shall move on to section 5. So you have to remember how a special marriage is done. When the conditions are fulfilled, the parties think that they are going to do the marriage, perform the marriage. They has to go to the marriage officer of that district, and they has to give intending parties have to give the notice, which should be in writing. And the form of the notice is mentioned in schedule 2, second schedule. You can also see the second schedule here. Now I shall show you the second schedule. This is the second schedule. You can see the notice for the intended marriage, to whom the notice is sent, to the marriage officer for that district. In that notice you will see that witness our hands in this last day. So this is the form of the notice which is mentioned in the second schedule. So in section 5 the notice is said, this is very important point, this cannot be omitted. First there will be notice, and the notice will be to the marriage officer of the district. And which district you will give the notice? The notice will be given in that district in which at least one of the parties to the marriage has resided for a period of not less than 30 days. So one of the spouse has to be has to reside prior 30 days immediately preceding from the date of such notice. So this is something you have to remember, that there should be a notice, and after the notice to the marriage officer shall keep all the notice within the records in his office, and shall keep enter a true copy of such notice in that book which is prescribed for that purpose, and that book is named after the marriage notice book, and such book shall be open for inspection. This is something you have to remember, that the marriage notice book, there the notice goes, and that marriage notice book is open for inspection at all reasonable times, not every time at the dread night. You cannot go, at reasonable times without fee by any person desirous for inspecting the same. Now the second thing is, the marriage officer, after getting such a notice, the notice shall be published in some conspicuous place in his office. Conspicuous place in his office, this means that such place will be visible to everybody. So anyone can come and see and take the I take the knowledge that such marriage is going to be performed, and here is this notice. And now, whether either of the parties to an intended marriage is not permanently residing, this is something the marriage officer will do. If the person is not permanently residing in the local limits of that marriage officer to whom the notice has been given under section 5, that marriage officer, what he will do, he will send the copy of such notice, he will transmit that copy to that marriage officer upon whose jurisdiction, upon whose limits such party is permanently residing. So what happens, when you send a notice to the marriage officer, there has to be 30 days period where either of the spouse has to leave. Then the notice will be given to the marriage officer. This is the prior condition. And if the parties are not living permanently there, the marriage officer shall send the notice, shall transmit the notice to that marriage officer upon whose jurisdiction that party is permanently residing, and that marriage officer will do the same. They shall upon receiving that copy, they will affix it to some conspicuous place of in his office. So this is something you have to remember. And then there is after the notice has been published, if there is an objection to that marriage, the objection should be based on the conditions of section 4. This is something important. Any party can do objection to that marriage, and the conditions of section 4 is contravening, that should be the objection, and before the expiration of 30 days. So after notice, there is a 30 days window where the objection can be given, and after the expiry of the 30 days, if there is no notice, that marriage may be solemnized. And if there is a notice, there is an objection, the nature of the objection shall be recorded in the writing by the marriage officer in the marriage notice book, and it will be explained to the person who is making the objection, and that objection shall be signed by him or on his behalf. So this is the procedure. After notice, there is an 30 days period of objection making to the marriage. And now there is section 8, the procedure on receipt of objection. When there is an objection received by the marriage officer, what the marriage officer shall do, the marriage officer shall not solemnize the marriage until he has inquired into that matter, and after the inquiry, if he is satisfied that this objection is not valid, this objection shall not prevent the solemnization, then only the marriage officer may go for the marriage. Okay. If the marriage officer is doing an inquiry and he is satisfied that such objection is not having that power to contravene that marriage, to prevent the solemnization of marriage, or there is another situation, if the objection is withdrawn by the person who is making that objection. Okay, so these two conditions has to be taken care of, but the marriage officer shall not take more than 30 days from the date of objection. So there is notice, then there is 30 days window where objection can be there, and after objection is taken, within 30 days he has to do the inquiry, the marriage officer, and the within 30 days he has to give his decision. This is the point. And arriving at a decision, he has to publish his decision within 30 days. Okay. Now the second point says that if the marriage officer upholds the objection and refuses to solemnization of marriage, so he finds that the objection is true, and he finds that he then refuses to solemnize the marriage, then what the parties, intending parties, can do, they can go for an appeal, and the appeal will be to in the district court, and the decision of the district court will be final and binding, and the marriage officer will act in conformity with the decision of the court. So this is the point. There is a provision of appeal also if the marriage officer refuses to solemnize the marriage. Now in section 9 there is the power of the marriage officer. While doing inquiry, actually what the marriage officer can do, they can summon any witness, they can examine the witness on oath, they can do discovery and inspection, they can compel the production of the documents, they can receive the evidence on affidavit, and also they can issue commission to examine that what the actual thing is going on, to examine the witness. So these all powers are given in the CPC, Code of Civil Procedure 1908. So the a marriage officer is having all the powers which is vested in the civil court. Civil court, they run with the procedure of the CPC. So the marriage officer shall have all the powers vested in a civil code. That is the point. And now, if it appears to the marriage officer that the objection made is not reasonable, the objection made is not reasonable and not made in good faith, what he will do, he will impose cost upon the person who has done that objection, and the cost, the amount that will be received, it will be by way of compensation, and it will not exceed 1000 rupees, and that cost will be awarded to the party. Some part of it will be awarded to the party or the whole. Okay. So this is the power of the marriage officer, which is in section 9, which is very important. He shall have all the powers of the CPC, and also when there is an objection which is not reasonable and not made in good faith, that will be a compensation, that will be a cost, and which will be in a way of compensation not exceeding 1000 rupees. So we are again and again revising the points so that they become memorized. Okay. Now section 10, procedure on receipt of objection by the marriage officer abroad. When an objection is made, marriage officer, what he will do, he will do an inquiry, and if entertains a doubt in respect thereof, he shall not solemnize the marriage. If there is any doubt, he shall not solemnize the marriage. But if there is any doubt, he shall transmit the record and record that statement, and shall transmit it to whom? To the central government, and the central government will give the marriage officer a decision, and that decision will be binding on the marriage officer, who shall act in conformity with the decision of the central government. This is the point. So when in section 11 we go in the section 11, that is declaration, the declaration by the parties and witnesses. Before the marriage is solemnized, the parties and three witnesses shall be in the presence of marriage officer sign a declaration in the form which is in the third schedule. Declaration shall be countersigned by the marriage officer. So you have to remember from this section 11 that there are the parties and the three witnesses. The counting of witnesses 3, and they shall in the presence of the marriage officer, they will sign a declaration, and that declaration will be countersigned by the marriage officer. If we go to the schedule third, this is the second schedule, and this is the third schedule. Declaration to be made by the bridegroom. Here this is bridegroom, this is made by the bride, and you can see here this is the three witness and countersigned by the marriage officer. So these are the points which were being talked about in section 11, and then thereafter we shall have section 12, which is talking about the place and form of solemnization of marriage. Where the so the question is, where the marriage will be special, marriage will be solemnized, what will be the place, what will be the form, what the persons will say. So these three questions have been answered in section 12. So it is said that there are two places where you can do. First is at the office of the marriage officer, or any such other place within the reasonable distance. That place should be in the reasonable distance therefrom, as the parties may desire. So here the desire of the parties has been given a respect, and for that reason there should be a payment of additional fees as prescribed. And then the question is, what form the marriage will be? In any form which the parties may choose to adopt. Now again, the desire of the party is respected. Then there is this point that each party has to say to the other. The bride will say to the bridegroom, the bridegroom will say to the bride, in the presence of the marriage officer and three witnesses. What they will say? They will say that I take the other person to be my lawful wife or husband. So this is the line you have to remember, that will be said by that two parties, intending parties, and after this line is said, the marriage will be binding. Okay. Now we move on to section 13, which is talking about the certificate of marriage. There will be a marriage certificate after the solemnization of the marriage. The marriage certificate will be given by the marriage officer, and uh, in the form which is mentioned in the fourth schedule. And before giving that certificate, in that book there will be a book, certificate, marriage certificate book. There he will enter everything, and that will be signed by the parties to the marriage and three witnesses. So this is the procedure. And the marriage certificate which is given by the marriage officer under section 13 of the Special Marriage Act, that certificate shall be deemed to be conclusive evidence. So this is a conclusive evidence. This evidence will be taken in the court. Now in section 14, this is saying that if the marriage is not solemnized within three calendar months after the notice has been given, or there is an appeal filed, and within 3 months of the decision of the district court, there is no marriage solemnized. So everything was positive, but no marriage has been solemnized within the 3 months. So the window, the scope is within the 3 months, everything has to be completed. If the marriage is not solemnized within 3 months, what will be the status of that marriage? The status of the marriage will be shall be deemed to have lapsed. So that will be lapsed, and no marriage officer shall solemnize the marriage until a new notice has been given. So again, if the status has been lapsed, then new notice has to be given, and again the same procedure has to be followed there. Okay. Now we move on to chapter 3, which is talking about registration of marriage celebrated in other forms. Now the other forms are which are the forms which are not talked about in chapter 2. These are the other forms. Any marriage which is celebrated other than the marriage solemnized under Special Marriage Act 1872 or under this act. So any marriage which is not solemnized under this act other than the marriage solemnized under this act, so any marriage outside that can also be registered under the Special Marriage Act after fulfilling these conditions. What are the condition? First condition, a ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. So the first condition is there is a marriage ceremony which has been performed, and this and with that, after that marriage ceremony, the parties are residing, they are living together as husband and wife in the society. Now there is no spouse living, no bigamy should be there. the neither of the parties should be idiot or lunatic at the time of registration. And here is another point which is different from the previous points. The parties have completed the age of 21 years at the time of registration. So it is talking about at the time of registration, the age of the parties will be completed 21 years. And then another condition, they should not be within the degree of prohibited relationship. And then there is another condition, the parties have been residing within the district of the marriage officer for a period not less than 30 days. So these are the six conditions which has to be fulfilled. First, there is a ceremony of marriage, they're living together, husband and wife. Then there should be no bigamy. Then there should be no lunacy or idiocracy. And there is the age of 21 years completed at the time of registration of both the parties. Then they should not be in the degree of prohibited relationship. Then the parties should reside in the jurisdiction of that marriage officer in the district for a period not less than 30 days. So these are the conditions. So after there is a application for registration, what the marriage officer will do after the application signed by the both parties, marriage officer shall give a public notice. Again the same thing is followed, there will be public notice and there will be 30 days window for objection. And after hearing any objection received, if the marriage officer is satisfied that the conditions of section 15 are fulfilled, then the marriage officer shall enter a certificate of marriage in the marriage certificate book, and the form is given in the fifth schedule. We can also see that, and such certificate shall be signed by the parties and the three witnesses. So here again the same procedure will be followed. This is the fifth schedule, certificate of marriage celebrated in other forms. So this is the marriage officer who will sign here, the husband, wife, and there is the three witnesses which we were talking about. So this is the whole thing of procedure which is in other forms. And again, if there is any aggrieved party within the whole procedure, they can go for an appeal within the 30 days of the order of the marriage officer. Actually, there is an appeal where the appeal shall be filed in the district court, and that again that appeal will be final. Decision of the district court will be final, and the marriage officer will comply with it, with that decision of the district court. And what is the effect of registration of this marriage? If the marriage is registered under chapter 3 of this special marriage act, then the marriage shall be deemed to be a marriage solemnized under this act. It is deemed to be solemnized under this act, and all the children who are being born after this marriage ceremony, they will be deemed to be legitimate children of their parents. Okay, now we move on to chapter 4, which is the consequence of marriage under this act. What will be the consequence if there is a marriage completed or solemnized under this special marriage act? The consequences is, if there is if the party was from the undivided joint family of the Hindu, Buddhist, Sikh, Jaina religion, then he has to be severed from such family. So after the marriage has been solemnized, he will be separated from that undivided family, joint family. And the section 20 says that if there is any right of succession of that property, any property, that right, or there if there is any disability of succession, that shall not be affected by this act. The rights and disabilities will be same as before. We have read that in Hindu Succession Act, there are disabilities for the murderers and other things. So this is something that will be followed even after there is marriage solemnized in the Special Marriage Act. Then section 21 says that succession of property of the parties married under this act, the parties who are married under this Special Marriage Act, how their property will be succeeded. The rules are to be followed of the Indian Succession Act 1925. So this is something we were talking about. Then that were the important things, especially. Thereafter, chapter 5, you have the same things from Hindu Marriage Act. Chapter 6, void marriage, voidable marriage, they're the actually the same condition and the same points. We shall go to the last chapter, which is of miscellaneous. Let's go to the miscellaneous. So this is chapter 8, miscellaneous. So section 43, this is penalty on married person marrying again. So person is doing bigamy and the person is marrying again under the special marriage act. So this is an offense, and that offense is taken care of in the section 494 and section 495 of the Indian Penal Code, and that marriage, second marriage, will be said to be void. Now the Indian Penal Code has been changed to BNS. You have to see the section there, but the concept is generally the same. No great change, on the section number has been changed. So there will be the penalty. The punishment of bigamy is again section 494 and 495 of the Indian Penal Code, and the such marriage will be void. So there is as section 45, that is not important. Then section 46, this is penalty. This is the marriage officer, if there is any wrongful action of the marriage officer, what the act shall do. The penalty for wrongful action of the marriage officer: any marriage officer who knowingly or willfully solemnizes the marriage under this act. Okay, that marriage officer has the knowledge, still he is willfully solemnizing the marriage, and the points he has not he has contravened, the points he has contravened, the points are: without publishing a notice, the marriage has been solemnized; within 30 days of the publication of the notice; or in contravention of any other provision of this act. So the marriage officer has a great duty under the Special Marriage Act, and anything done, wrongful done, with knowledge, with intention, willfully, that will be punished. But the punishment is simply simple imprisonment, imprisonment for the term which may extend to 1 year, so up to 1 year, or fine up to 500 rupees, or both. This is the penalty for the marriage officer. And as we have already know, the section 47, the marriage certificate book will be open for inspection at reasonable times, but this will be with fees. There will be fees, there will be application, fees payment to the marriage officer. And that marriage certificate book, whatever marriage certificate book is saying, that is admissible as evidence in the court. Now in section 48, the transmission of copies in marriage records. So whatever marriage record is there, every marriage officer in the state has to send that birth, death, marriage of the state in interval periods to the registered general, of birth, death and marriage. So there is a little correction: every marriage officer of a state has to send to the registered general of birth, death and marriage. Okay, so this is the full designation, there the true copies of the marriage records has to be sent. And now there is section 49, if anything error in the and the marriage officer has discovered that error, that marriage officer has a duty to correct that error within 1 month of discovery, and that error will be corrected in the presence of that persons married, and also so the thing is, parties to the marriage and also two other credible witness. So the thing is, three witnesses were there in that marriage, but here for the correction there is parties and the presence of two witnesses, and every correction shall be attested by the witness in whose presence it was made. So attestation is very important. And the power to make rules of this Special Marriage Act, regarding the Special Marriage Act, for carrying out the purposes of this Special Marriage Act, that will be conferred upon the central government and the state government. and that will be done by the notification in the official gazette. Now, as we have completed the Special Marriage Act, and we have also seen the schedules, up to the fifth schedule, we have seen everything. I hope you have liked this video, and this is all from my side of the Special Marriage Act 1954. If you have already read the Hindu Marriage Act, you will be benefited from this video. And in this channel there are videos of the Hindu Succession Act, Hindu Adoption and Minority Act, and they are very more research. This video is made in haste, but they are researched, and I have taken time to explain. I have explained every sections of Hindu Succession Act, Hindu Minority and Guardianship Act. So please go check out those videos. Thank you so much.